Alright, welcome back guys. Nandito na tayo sa chapter 2, capacity to buy or sell. Alright, sales law pa rin ito. 1489 talks about who are the persons allowed to enter into a contract of sale. So general rule, all persons, whether natural or juridical, are allowed to enter into a contract of sale. So lahat pwede. Exceptions are number 1, those who are absolutely incapacitated, and those who suffer from relative incapacity. So ito ay general definitions itong absolute incapacity at saka relative incapacity. I-discuss natin to one by one, okay? So let's go first to those absolutely incapacitated to enter into a contract of sale. These are people who cannot bind themselves to enter into a simple contract. These are people mentioned in your obligations and contracts. These are the following. Under Article 1327 of the Civil Code, the following cannot give consent to a contract. Number 1, unemancipated minors. So, sa ngayon, yung term na unemancipated, wala na yan. Parang minors na lang talaga. So, ano bang ibig sabihin ng minor? A minor is a person who is below 18. So, paano kapag eksaktong 18 years old kaka-birthday niya? Hindi na siya minor. Okay, so this is also one of the reasons na kapag bata, kailangan mo talagang intindihin. Kasi kapag minor, hindi pa siya, kumbaga, hindi pa maayos yung kanyang decision making o kanyang utak, kaya kailangan iintindihin mo. Number 2, insane or demented persons. Ito yung mga baliw, yung may sira yung ulo. So, hindi sila pwedeng pumasok sa contract of sale. And then number 3, deaf mute, who do not know how to read and write. So, ang keyword dito is read and write. Deaf mute, deaf ka, tapos mute ka, pero at hindi ka pa marunong magbasa at magsulat. Kasi kapag deaf mute lang, pwede naman sila makapag-enter into a contract of sale kasi nakakaintindi sila through braille. Diba? Yung kinakapa na salita. I mean, I'm not really sure if you're familiar with it. If you're not familiar with braille, you have to Google it. Even though you're deaf and you're mute, even if the person is deaf or mute, the person can still understand, therefore he can still convey yung kanyang consent or objection dun sa isang particular contract. So, pag deaf mute lang, I will argue na pwede siyang magbigay ng consent. Pero kapag deaf mute na hindi marunong magsulat at magbasa, yun ay yung isang tao na hindi pwedeng pumasok sa kontrata kasi absolutely incapacitated siya. Okay? So, punta naman tayo dun sa relatively incapacitated. So, these are the people discussed in the next 2 articles. These people are neither minors or insane or demented people. They are of legal age and perfectly healthy, but because of their situation and circumstances, they are incapacitated to enter into certain kinds of contract of sale. Usually kasi may conflict of interest kaya hindi sila makapasok. Incapacitated sila. Pero relative lang yung incapacity nila. Okay. So, just to go back, and this is a commonly asked question. What happens if a minor sells a property to a person of valid age? So, since nandito na tayo sa topic ng isang minor de edad, discuss na rin natin to. Under the Civil Code, a sale by a minor for a property is voidable, which means that it is valid until it is annulled. However, there will be a problem in the registration of the sale in order to have the title transferred in the buyer's name, as the minor would have to execute a deed of sale. And since minor nga siya, paano siya mag-execute ng deed of sale? Diba? A notary public would not acknowledge the sale knowing that the seller is a minor, as the latter would have to present herself personally together with a valid ID with a picture before the notary public. So, halimbawa, noong mga panahon na notary public ako, bigla may pumunta sa opisina. Sabi, magpapanotaryo daw. Ngayon, yung seller, minor. Yung ganong klaseng dokumento, hindi ko talaga inonotarize yon kasi alam ko na bawal yun eh. And ang mangyayari dyan, kapag ginawa ko yun, I open myself to a possible case against my privilege to notarize documents. Okay? There's another issue also, yan yung payment ng capital gains tax. Yung seller required siya magbayad ng capital gains tax so that the buyer could obtain a certificate of payment of tax from the BIR. So the certificate of payment of tax is one of the documents needed before the register of deeds. In order that the seller could pay the CGT, the seller needs to have a TIN number. So, a minor cannot obtain a TIN number. So, hindi rin po pwede. Alright? So, as you can see, may binabasa natin yung, yung theoretical, but at the same time, ina-apply natin yung real-life application niya talaga. Kaya tayo napupunta sa mga BIR at saka sa mga Register of Deeds kasi gusto ko maintindihan ninyo yung talagang totoong nangyayari kasi hindi lang to purely theoretical Okay? So, let's now proceed to those persons who are relatively incapacitated. So, Article 1490 states that the husband and the wife cannot sell to each other except, number 1, when there is a separation of property that was agreed upon in the marriage or otherwise known as in the marriage settlements, otherwise known as prenuptial agreement, or there has been a judicial separation of property. Okay, bakit ganito? Kasi, tatalon tayo sa family law guys ha. O, pasensya na kayo, tumatalon-talon tayo. Pero sana ma-appreciate ninyo na yung pagtatalon-talon ko, para mas maintindihan ninyo yung pinag-aaralan natin. So, nakalagay dun tatalon tayo sa family code. Okay, ano ba nakalagay sa family code? Ang nakalagay sa family code, after 1987, kasi 1987, na yung family code na nagawa or na promulgate or naging effective rather. After 1987, ang governing rule sa property regime ng mag-asawa is tinatawag nating ACP. Ano ba yung ACP? Absolute Community Property. Ano ba yung Absolute Community Property na yan? Ang ibig sabihin na yan is what is mine is yours, what is yours is mine. So, kung ano yung meron yung asawa mo, sa'yo din yun. At kung ano yung meron siya, sa kanya din yun. Kung ano yung meron siya, sa'yo din yun. Kung ano yung meron sa'yo, sa kanya din yun. So, kumbaga shared kayo. Kumbaga parang kanta ng Spice Girls, two become one. Okay? So, natural. Pag i-apply mo to, the husband cannot sell to each other. Kasi, they both own the property together. Di ba? Pag binenta mo sa wife mo, yung property, you still own it. Kasi, you jointly own the property together. So, it doesn't make sense. Kaya, bawal, incapacitated yung husband na magbenta sa kanyang wife. Okay? So, may exception yan. Yung number 1, may separation of property na nag-agree sila dun sa prenuptial agreement. Okay, pause muna tayo. Ano ba yung prenuptial agreement na yan? Okay, ang prenuptial agreement na yan, ang prenuptial agreement is ibig sabihin, that means before, nuptial means marriage. Agreement means agreement. So, before marriage agreement. Ano ba nakalagay sa prenuptial agreement? Sa totoo lang, kahit ano, pwede mong ilagay sa prenuptial agreement. Of course, you have to follow yung obligation natin, which is the parties may stipulate whatever they want in a contract as long as it's not contrary to law, morals, public order, public policy, etc. So, dito, sa prenuptial agreement ninyo, pwede nyo sabihin na complete separation of properties kayo. Ibig sabihin, sa akin lang yung property na sa akin, pag may-ari ko, pag nagkasal tayo, sa akin pa rin yon. Wala kang share doon. Okay? At siya naman, yung property na nasa kanya, pagkasal nyo, sa kanya lang din yon. So, complete separation of property kayo. Kapag may ganun kayong agreement sa prenuptial agreement ninyo, ibig sabihin, pwede kayong magbenta ng property sa isa't isa. Diba? O bakit naman oo ngayon? Syempre, magkahiwalay nga yung property ninyo. Hindi kagaya nung una, kung wala kayong prenuptial agreement, pareho naman kayong may-ari dun sa property, bakit mo pabibenta sa asawa mo? Pareho na nga kayong may-ari, di ba? Naiintindihan nyo ba, guys? Kung di nyo naiintindihan, i-rewind nyo, tapos i-play nyo ulit itong video na to. Yung portion na to. Okay, so when there has been a judicial separation of property. So, parang number 1 lang din yun, except dito, yung judge na yung nagsabi na may judicial separation of property na magaganap. So, paano naman nangyayari yun? Well, nangyayari lang yun kapag nagkaroon na ng kasuhan at nagkaroon ng order yung judge. So, it presupposes na nagkasuhan talaga. Kasi hindi naman mag-i-issue ang court ng separation of property hanggat walang nagkaso. So, ibig ba sabihin nun, nag-away yung mag-asawa? Well, posible, baka ganun na nga yung nangyari. Nag-away sila, hindi sila nagkaunawaan sa paghihiwalay ng property nila. Kaya nagkaroon ng judicial separation of property. Okay? Next slide na tayo ha. There is a relative incapacity between a husband and his wife to buy and sell from each other. This means that the husband and the wife are prohibited from selling property to each other. A sale between them violates Article 1490 and the sale is considered void from the very beginning as it is expressly provided by law. Okay? But are they not allowed to buy and sell from each other? What is the reason behind the law? Okay. So, very important na dapat alamin ninyo yung reason behind the law para mas maunawaan, mas ma-appreciate ninyo kung bakit may mga ganito tayong mga batas. Kasi sa totoo lang guys, marami tayong mga batas na sometimes, well, may mga batas na parang nonsensical, nonsense di ba? May ibang mga batas na ganoon. Pero may mga batas naman, well, majority ng mga batas is, kumbaga, based on common sense lang din talaga. Alright? So, ano ba yung reason behind the law? The reason is to protect third persons who, relying upon the supposed property of either spouses, enter into a contract with either of them only to find out that the other property relied upon was transferred to the other spouse. So, halimbawa, may utang si creditor. Halimbawa, si husband na lang may utang siya kay creditor, kay C. C for creditor. Tapos ngayon, hindi niya nabayaran yung utang niya. So, ngayon, naghahabol si creditor sa kanya. Ang ginawa ngayon ni husband, niliquidate niya lahat ng property niya, binenta niya sa asawa niya. Pero sa totoo lang, medyo nonsense yun. Bakit may bibenta sa asawa mo yung property? Well, probably siguro bibenta niya yung lupa kasi yung registered owner dun sa lupa, siya lang. Benta niya sa asawa niya para yung registered owner ng lupa sa asawa niya. Pero again, parang hindi papasa sa register of deeds yung ganun eh. Pero ang reason behind the law dito is para hindi ma-circumvent yung batas. Siguro, wag lupa, kotse. Si husband, mayroon siyang BMW nakapangalan sa kanya, siya registered owner, binenta niya sa wife niya. Pero kung ganun lang din naman, naiikutan mo yung batas, bakit sa wife mo pa ibibenta, di ba? Di benta mo na lang sa best friend mo, kaya sa mother-in-law mo, o kaya sa anak mo. Di ba? Kung yun lang din yung gagawin mo, which is to escape yung utang mo sa mga creditors mo. Bakit sa wife mo pa ibibenta? Okay, so again, yung purpose nito is to protect creditors from a situation wherein the husband is in debt, and to avoid paying his debt, he will sell to his wife his assets. This will in fact defraud the creditor. Alright? So 1491, the following persons cannot purchase the property of the following. Well, the following persons cannot purchase the property of the following persons. Okay. Well, siguro ayusin lang natin to. These persons, lagyan natin these persons. These persons cannot purchase the property of the following person. So, yung guardian, hindi niya pwedeng bilhin yung property ng kanyang ward. Ano ba yung ward? Well, yung ward, pwede siyang infant or incompetent person. Tapos, inaalagaan siya ng guardian. Kasi, syempre, yung guardian lang yung lagi niyang kasama. Pwedeng bubulong-bulungan siya ng guardian niya. Tapos, biglang makikita siya ng appreciation sa guardian niya. Lahat ng mana niya, lahat ng property niya, binigay niya sa guardian niya. Diba? And then, syempre, hindi niya pwedeng ibigay lahat yun sa guardian niya kasi tatalon tayo sa succession law, ha? Pwede ba sabihin natin, merong isang matandang babae, tapos wala na siyang asawa, may mga anak siya, pero yung mga anak niya, hindi siya masyadong binibisita sa kung saan man siya nakastay. Meron siyang care, bantay doon, may guardian siya, and then yung guardian niya mabait sa kanya. So, ngayon, dahil mahal na mahal niya yung guardian niya, more than na mahal niya sa anak niya, ang gusto niyang gawin, bigay lahat ng property sa guardian. So, gumawa siya ng will, tapos pinasa niya sa guardian. Valid ba yon? Ang sagot, hindi. Kasi under succession law, merong tinatawag na legitime. Ano ba yung legitime? What kind of animal is that? Ang ibig sabihin ng legitime, yan yung compulsory na mana ng bawat heir. So, ngayon, ang gagawin ngayon ni Lola, dahil alam niya na hindi niya pwedeng ipasa through inheritance or through hindi niya pwedeng ipasa through yung letter ng mana. Ang gagawin niya, bibenta niya na lang sa guardian niya. Benta niya ng mas mura. So again, tatalon tayo dun sa pinag-aralan natin last time. Gross inadequacy of the purchase price, will that affect the sale of the property? The answer is no. So, halimbawa, binenta niya yung kanyang 10 million peso property sa halagang 50,000, valid pa rin yon. Okay? So, pero again, baka nga ma-interpret yun as donation. So, rules on donation will apply. Or baka pwedeng i-challenge ng mga anak, sabihin ng mga anak, at the time, wala sa sarili na yung kanilang nanay. Kaya binenta ng nanay dun sa guardian at a very, very low price. Okay, tumalon na ako, pero ang gusto ko lang i-point out dito is hindi pwedeng kumuha ng property o bumili ng property yung guardian sa kanyang ward dahil nga may conflict of interest. In the same line na yung agent, hindi niya pwedeng bilhin yung property na binigay sa kanya ng kanyang principal. Again, conflict of interest. Lahat to puro conflict of interest. Tatapusin ko lang. Executors and administrators cannot purchase the property of the estate under administration. Okay, so dito tatalon tayo sa succession law. Sino ba yung executor? Okay, the executor is the person appointed to administer the estate of a person who has died, leaving a will which nominates that person. Okay, medyo that's probably a lot to take in. So, ang kino-contemplate nito is may taong namatay. Okay? Kapag ang isang tao namatay, lahat ng ari-arian niya ilalagay mo sa isang parang imaginary na swimming pool. Yung swimming pool na yon, ang tawag mo doon ay estate. Okay? So, imagine mo yung swimming pool, empty swimming pool. Tapos nung namatay yung tao, lahat ng ari-arian niya, mga titulo niya, mga lupain niya, mga kondo, kotse, jewelry, sasakyan, etc. All of it, buildings na kanyang pag-aari, ilalagay mo dun sa swimming pool. Okay? So, usually, nagmamatter lang to kung marami kang pera. Kung wala kang pera, edi wala namang pag-aawayan yung mga anak mo kasi wala ka namang iniwan sa kanila di ba? Pero, kung marami kang pera, halimbawa, si Lucio Tan or kung sino mang millionaire na namatay, lahat ng property mo ilalagay sa imaginary na swimming pool at tawag mo din ay estate. Okay? So, yung estate na yan, ang mangyayari dyan is, i-divide mo yung property sa yung mga tagapagmana. Okay? So, dapat, kung walang will, susundan mo yung mga nakalagay sa ating batas, which is yung nakalagay na hatian sa succession law. Kung merong nakalagay naman kung merong will naman, susundan mo yung will. Pero, again, yung will na yan, i-check mo muna kung valid yung will na yan. Kasi kung may isa dyan na tagapagmana na hindi sinama dun sa will, void yung will na yan. Okay? Follow me so far, guys? Okay. So, ngayon, namatay na yung tao. Lahat ng property niya nandun sa swimming pool. Sino magdi-distribute? Ang sagot is yung executor. Ngayon, paano naman siya naging executor? Ang sagot, yung namatay yung tao, yung testator, gumawa siya ng will. Tapos dun sa kanyang will, specify na, halimbawa, ang aking firstborn child, ang pinang-panganay ko, siya ang magiging executor. Or pwede niya sabihin, ang magiging executor ng will ay ang aking third child na abogado, kasi lahat sila, yung ibang mga anak ko, puro mga doktor o engineer. So, yung anak kong abogado ang gusto kong maging executor ng will. Okay? So, ang kino-contemplate ng isang executor is merong will, and doon sa will na yon, siya mismo yung nakalagay as executor. Okay? So, ano naman tong administrator na to? Okay, when a person is male, he is called an administrator, while if he's a woman, he is called an administratrix. An administratrix or administrator is appointed by the court where the testator had made an incomplete will without naming any executors or had named incapable persons, or where the executors named refused to act. Okay, kino-contemplate naman na scenario na to is either kulang yung will na ginawa ng testator. Yung testator, yan yung namatay ha. Kulang yung will na ginawa ng testator, or yung will ng ginawa ng testator ay walang ginawang will yung testator. So, kung ganyan, paano na yung swimming pool? Sino na yung magdi-distribute ng ari-arian? Ang sagot, yung court ang mag-a-appoint ng either administrator or administratrix. Okay? Yung isang scenario pa na kino-contemplate na i-appoint yung administrator or administratrix is if may valid will, may nakalagay na testator, pero may nalagay na executor, pero yung executor ayaw niyang gampanan ng kanyang trabaho bilang testator or executor pala, sorry. Halimbawa, sabihin natin nasa US siya. Paano naman talaga niyang gagawin yung trabaho ng isang executor kung nasa USA siya, doon siya nakatira? Diba? So, again, kapag may will, executor ang tawag. Kung walang will, administrator. Ano ba yung purpose nila? Well, ang purpose nila is sila yung magdi-distribute ng property na nakalagay doon sa estate. Okay? Doon sa swimming pool na tinatawag nating estate. So, dito sa example na to, pwede bang bumili yung executor and administrator ng lupa na nandoon sa swimming pool na yon na hawak nila under their administration? Ang sagot, hindi. Incapacitated sila. Bakit sa palagay ninyo? Well, ang sagot, syempre, dahil may conflict of interest. Alright? Next. Public officer or employees, the property which has been entrusted to them. So, again, para siyang yung kanina lang din na testator, tapos may property na in-entrust sa kanya. Number 5, justices, judges, prosecutors, clerks of courts, and other employees cannot purchase property which is under litigation before their court. O halimbawa, nag-file ka ng isang kaso tungkol sa certain property na to, tapos yung property na yan, naka-pending yan sa isang particular court. Hindi pwedeng bilhin yan ng kahit sino man na nandoon sa court. Again, kasi conflict of interest yan, guys. So, why are the contracts between these people concerning these objects of sale are not allowed? The reason behind this particular article of the law is to prevent fraud on the part. I think there's no such thing as frauds. Fraud on the part of the persons enumerated therein, and to minimize the temptation to the exertion of undue and improper influence. Simply, this is to avoid conflict of interest. Very, very beautiful. Napakaganda ng kanyang explanation para ma-minimize yung temptation. Okay? So, but what happens if there was still a sale between these people in 1491? How will it be treated? Okay? So, between 1 to 3, items 1 to 3, the sale shall be voidable. Because in such cases, only private interests are affected. Voidable means valid until cancelled or valid until annulled. Yung, ano ba yung 1 to 3? Yung guardian and the ward, agents and the property entrusted to them, and executors, administrators with respect to property entrusted to them. So, on the other hand, yung 4 and 5 naman, this is void from the very beginning kasi public interest is already involved. Like yung public officers and employees, may property na nasa administration nila, hindi nila pwedeng bilhin. Or yung court officials, may property na nakapending sa kanilang sala, hindi nila pwedeng bilhin yon. So, void yan from the very beginning kasi public interest yung involved dyan eh. Okay, 1492. The prohibition again in Article 1490 between the husband and the wife, and 1491 between the guardian and the guardian's agents, etc. are applicable to sales in legal redemption, compromise, legal redemption, the property sold earlier and is brought back again. So, to buy back, yan yung redemption. Yung compromise, parties avoid litigation. Para kumbaga nagkasundo na kayo, nag-enter kayo sa amicable settlement para wala nang kasuhan. Number 3, renunciation. The creditor gratuitously abandons his right against the debtor. This is otherwise known as condonation or remission or release of debt. Yung renunciation, ibig lang sabihin niya, sige, huwag mo na akong bayaran. Okay na tayo. So, apparently, yung prohibition dun sa 1490 and 1491 are also applicable in the following sales. Alright? And the following transactions: legal redemption, compromise, and renunciation. So, I think we are done now with chapter 2. We're done. Okay, so we will proceed with chapter 3 next meeting. So, we'll stop here. And hopefully, you learned something new today. And that's it for now. Alright, I'll see you again. Thank you.